But at the same time, granting a motion to strike is appropriate when the plaintiff, as is the case here, has failed to present evidence sufficient to create an issue of fact on his claims. And in addition, the court may not draw inferences from the evidence that defy logic and common sense. That's the Austin versus Shoney's case, 254 Virginia 134. So the issue here, Your Honor, is a couple-fold, and I'll take the statements, well, two of them in one category and one of them in the other category. But I think we're all clear that the sole issue here is whether Amber Heard can be held liable to Mr. Depp for defamation arising from the 2018 op-ed and the 2018 op-ed alone. And to establish that, Mr. Depp has to prove the following elements. He has to prove that the publication of the op-ed and that it was written by Ms. Heard. He has to prove that the statements in the op-ed were both false and defamatory. So falsity, and that they contained a sufficient defamatory sting, and he has to show that the statements were made with the requisite intent. In this case, actual malice on the part of Amber Heard. I'll save that argument till the end, Your Honor, and I'll focus on the first two at this point. And because it seems like plaintiff is proceeding under a theory of defamation by implication, under the Pendleton case, 290 Virginia 162, plaintiff bears the burden of proving that the statements at issue were designed and intended by Ms. Heard to imply a defamatory meaning. Designed and intended to imply a defamatory meaning. So, and to satisfy those first two elements, publication and falsity and defamation or defamatory nature of the statements, Mr. Depp bears the burden of proving that by a preponderance of the evidence. And to satisfy the requisite intent and show that Ms. Heard acted with actual malice, he has a heightened standard of proof that he must prove by clear and convincing evidence that Ms. Heard acted with that malice. So just want to talk about the two statements on domestic abuse in the op-ed. And Your Honor's well aware of the ample Virginia case law talking about how you have to view the op-ed as a whole, you have to view words in context. So these are the statements that read, then 2 years ago, I became a public figure representing domestic abuse. And then the other statement that says, I had the rare vantage point of seeing in real time how institutions protect men accused of abuse. Now, those statements are entirely opinion, except for, according to Mr. Depp, the discussion of domestic abuse. So the statement, I became a public figure representing domestic abuse, and the statement in the second sentence that Mr. Depp was a man accused of abuse. The rest of those are inactionable opinion statements. Now, the evidence adduced thus far, Your Honor, shows that Mr. Depp can't sustain a claim on these for two reasons. First of all, the statements are true on their face. I don't think that there's any dispute about that, and that's been the subject of some testimony in this case. 2 years before she wrote the op-ed, Ms. Heard did, in fact, become a public figure representing domestic abuse when she obtained a domestic violence restraining order against Mr. Depp, and Mr. Depp was indeed accused of abuse. Those are facts that are true. Now, to the extent that Mr. Depp will argue that he's proceeding on a defamation by implication claim, again, the court should grant the motion to strike because the undisputed evidence is that he did, in fact, abuse Amber. Now, there's a dispute in this case. There's ample evidence that he physically abused Amber, but we acknowledge that there's a dispute in this case on that. But what there isn't a dispute in this case is non-physical abuse. Both Mr. Depp and his expert Shannon Curry have testified that abuse may come in many forms. It may be physical, certainly, but it may also be verbal, may be emotional, may be psychological. You'll recall Mr. Depp even kind of setting the baseline for what abuse was when he talked about the non-physical abuse that he allegedly suffered at the hands of his mother. He said it was worse than the beatings, and the example he gave was that his mom used to call him One Eye as an example because he had a lazy eye, I guess, as a child. That was something that Mr. Depp himself said was abuse, his mom calling him One Eye. So we setting aside the evidence of physical abuse in this case, which is already overwhelming, Mr. Depp's claims relating to these two statements should be stricken because of the ample and undisputed evidence in the record of non-physical abuse by Mr. Depp toward Ms. Heard. There's evidence in the record of recordings, messages, including messages written in blood with his finger, blood and paint, vile names, shouting, menacing and threatening statements, There's the video, the kitchen video in Sweetser. There's the audio of him calling Miss Heard, like I say, numerous vile names. There's the audio of him asking her to cut him, and whether she wanted to be cut. So there's plenty of evidence out of the words or out of the mouth of the plaintiff in this case that constitutes non-physical abuse of Miss Heard. Again, under the standards set forth by his expert and the plaintiff himself. Those are far worse than his mother calling him one eye when he was a child. In addition to that, Your Honor, there's Travis McGivern's testimony from yesterday in which he testified that at a minimum on the night of March 23rd, 2015, both parties were being verbally abusive to each other. Mr. McGivern also testified about Mr. Depp, quote, rearranging her closet, throwing racks of clothing down onto the floor and throwing at least one rack down the stairs. Now, in California, property damage alone can be a basis for getting a temporary restraining order under California law. So further evidence of non-physical abuse or non-physical toward Miss Heard. You saw the cupboards in the Sweetser kitchen video. And then Dr. Laurel Anderson, Your Honor, testified that she believed that the parties engaged in mutual abuse and that at least some of the time that was initiated by Mr. Depp. This is all evidence. We haven't gotten to put on our case yet. And to the extent that this case proceeds, and that will start now, but this is all evidence that has come in while plaintiff controls the playing field of what evidence has come in, and he can't overcome that. In this case, Your Honor, if Mr. Depp abused Miss Heard physically, verbally, emotionally, or psychologically even one time, then she wins on those claims. Then she wins. It's that simple. And the evidence is overwhelming and undisputed in the ways that I've just described that he did. So for that reason, Your Honor, those claims should be stricken. And I'll just cite the Union of Needle Trades versus Jones case. This is 268 Virginia 512 that states, if the plaintiff does not establish the falsity of the statement by a preponderance of the evidence in his case in chief, he has not met his threshold burden, and the trial court should strike the evidence and grant summary judgment to the defendant. That's exactly what should happen here. Now I'll move on to the second issue, which is the headline containing the phrase sexual violence. That should be stricken for a couple reasons. First, Your Honor, the evidence has established that Ms. Heard didn't write the headline. Mr. Doherty from the ACLU, that's the only evidence that's come in this case thus far. Plaintiffs control the evidence.
Well, I understand, but there's also a stipulation that Ms. Heard would not be called in the plaintiff's case because they would then use her testimony for part of their case. In your case, right?
That's correct, Your Honor.
Yeah, I agree, and that goes to a different issue that I'm not arguing. I'm not arguing that the court should strike because they haven't put Ms. Heard on to testify about the headline.
But I assume part of that would be that they would, I guess they intend to get from Ms. Heard is that she either wrote it or republished it.
Yeah, what happened the next day is Ms. Heard posted it on her Instagram account and said, look what I published yesterday in the Washington Post. So she adopted the title, and her name was on the article which contained the title.
And Mr. Ronborn, the only reason I'm sorry to interrupt you, only because I know that was a stipulation, so it's hard for me to say that that's all the evidence for motion to strike if there's a stipulation that they're still going to get more evidence in on that particular issue.
I think, and I'm happy to hand the court the transcript of the April 8th hearing, because one of the things that we're not arguing today is that because they haven't put in evidence of I think it was a tweet, but Mr. Chu says it was Instagram, I don't know, whatever it was, that because there was...
It was a tweet adopting the op-ed she published the day before in the Washington Post.
Okay.
All right, so what I'm not arguing today is that because they haven't gotten that tweet into evidence or had Ms. Heard say that she tweeted that we're entitled to summary judgment at this point. I'm not arguing that, but that's all that we discussed on April 8th, and I'm happy to hand the transcript up, Your Honor. And we actually it wasn't a stipulation, it was simply an agreement that they didn't need to call her in their case in chief to make that point. And then Ms. Bredehoft said we'd have to agree on the language of any stipulation, and they haven't proposed anything to us and haven't gotten back to us. So I think that that's only relevant we're not basing our request for motion to strike here on Ms. Heard not having testified to sending that tweet.
But you're saying for the motion to strike, the only evidence before the court is that the Washington Post wrote that title.
Correct, and that's very different from what happened the next day. the stipulation didn't go toward who wrote the title. That was never part of anything, and it's undisputed, and Ms. Heard will testify that she didn't write the title.
Well, I understand that, but I think
it's not undisputed, Your Honor. I apologize for interrupting.
Okay. But I think the issue is that whether it was republication.
Well, and I'll get to that next.
I know, but the problem is, how do I do a motion to strike when that evidence isn't before me yet?
Well, the republication isn't. So the evidence that's before you is that the Washington Post wrote the headline, or that Ms. Heard didn't, and that's the only evidence, and that's not going to change. The tweet, which was the only subject of the discussion at the pretrial conference, where there was no stipulation, it was just an agreement that we're not going to base a motion to strike on them not introducing evidence of the tweet. That was what it was. I'm happy to hand the transcript up if Your Honor would like to see that. But that isn't actionable because under the Lakova versus Halper case, 995 F3rd 134, retweeting a link doesn't constitute republication. Now, that case dealt with
it does if you add something to it, but I just don't know the evidence.
Your Honor, very quickly, it's a judicial admission. They admitted in Ms. Heard's answer, she admitted to the tweet. So that establishes that she adopted the op-ed in its entirety, and it was discussed. We talked about judicial admissions. One was the op-ed itself. The second, and this is reflected
Your
in
Honor, if I could finish my argument, I mean, I would appreciate.
I can't wait to oppose this.
That's fine. Go ahead. Go ahead. Go ahead.
So, and again, we can look at the transcript.
You understand my concern.
I do understand your concern, and I guess what I'm saying is that there's two levels. One is there's no dispute, and there's not going to be a dispute that she did not write the headline. So then you look at is the tweet actionable? And the argument here is that as a matter of law, retweeting something isn't actionable. And so, as under the Lakova case, 995 F3rd 134, and that case dealt with hyperlinks and how those aren't actionable. But to be very clear, nothing that was discussed on April 8th, nothing that was discussed at that pretrial conference was in any way relating to any stipulation about who wrote the headline. It was simply that they need not call Ms. Heard in their case in chief to get her to say that she sent a certain tweet. And that tweet's not in evidence yet, but I assume that they'll try to put it in evidence at some point. But the tweet doesn't need to be in evidence for you to strike this claim on that basis. So even assuming that the headline implied certain conduct by Mr. Depp, again, Mr. Depp can't meet his burden of proof on this. Third, Your Honor, he can't prove that Ms. Heard acted with actual malice. Mr. Depp hasn't introduced evidence sufficient to permit him to meet this. Now, again, this is a heightened burden of proof. He has to show actual malice by clear and convincing evidence. And as the Bose Corporation case from the U.S. Supreme Court, it talks about the role of judges as gatekeepers of the Constitution, of the First Amendment, and the role of barring entry of a judgment that's not supported by clear and convincing proof. Now, that case was about appellate review of First Amendment issues, but the same holds true for Your Honor here. Here, Mr. Depp hasn't introduced any evidence, and there can't be a reasonable inference drawn that would permit a jury to find that he's proven by clear and convincing evidence that Ms. Heard wrote the words with actual malice. And again, we go back to the testimony of Mr. Doherty, which was their witness. They put him in, and Mr. Doherty, the only evidence relating to intent or anything relating to this op-ed, which was, again, maybe Mr. Chu will try to say that we stipulated to Ms. Heard's intent on April 8th, which of course we didn't. But the only evidence that has been presented in this case, Your Honor, by Mr. Doherty was that the op-ed wasn't Ms. Heard's idea, that the ACLU asked her to write the op-ed, and indeed that they even wrote the first draft, and then that Ms. Heard vetted the finished article with her lawyers and with lawyers from the ACLU to make sure that it wasn't problematic. That is the only evidence in the record. And on that evidence, there cannot be a conclusion that Ms. Heard acted with the actual malice that's necessary, particularly when you consider the heightened burden of proof. So reviewing the op-ed as a whole, with the court acting in its appropriate function as a gatekeeper of the First Amendment, we ask that the court strike plaintiff's evidence and award summary judgment to Ms. Heard, either in whole or in part. Thank you.
All right. Thank you. Yes, sir.
Good morning, Your Honor. May it please